Welcome friends, welcome to Simzuu.
We present with you and before you another concept of natural justice. Yes friends, we have started a new series, Concepts in Labor Laws. And in Concepts in Labor Laws, we have already seen origins of natural justice, and we are going to take this or stretch this topic a bit further. And today I am going to talk with you on the first principle of natural justice, which is enshrined in the maxim that is Audi Alterem Partem. Now you see friends, Audi Alterem Partem is a principle of natural justice which embodies the essence of fairness, the essence of no bias, the essence of the right of giving heard. And you see that the parties should have their opportunity to present their case. Let's presume that there is a case. And each and every party has to have an opportunity to present its case. Sometimes there are three parties this way and two parties here, but everybody should be heard in the process. Otherwise, we are not giving them, or rather we are denying them the principle of Audi Alterem Partem, or the rule or the first right of natural justice. Now friends, so what is Audi Alterem Partem? The first rule of natural justice. This is the primary rule of any humanized statute which is acknowledged by the laws of men and God. It's not only laws of men, it's God also. And we have a story from the Bible that in the first chapter of the Bible, that is the Genesis, the old story everybody knows, it was Adam and Eve, and there was a tree which contained apples. And the story goes further. It's in the first chapter of the Bible, that is the Genesis, that God came and God told Adam, you are not going to pluck this fruit and eat it. You are not going to take this apple. This is an express direction from God. This is an express ordinance from God. This is an express rule from God that you are not supposed to touch it. And as you understand friends, God is supreme in His powers. God went away. Story further progresses that it was Eve who instigated him, that come on, nothing happens, pluck the fruit. Adam plucked the fruit, and then God came back. Now Adam is in no position to tell God that you never told me this. God is supreme in His powers. And the story further goes that whether did God punish Adam? And the answer is a very simple no. Why did God not punish Adam? The answer is that instead of punishing him, God asked him a question, do you want to put up a defense? Now this principle of natural justice, or the right to put up a defense, is contained in the first maxim itself, that is Audi Alterem Partem, which is a part of our discussion friends. The principle is that nobody should be condemned unheard, and every party will be getting an opportunity to put forth his case. Just think of a situation, it is your case, and the judge hears your opponent and does not hear you. How would you feel? So the question is that all the parties should be heard. Now friends, no decision also is to be taken without giving hearing to both the parties. Now this is just a corollary, or you can say the reverse of what I said earlier, that the court should hear both the parties and nobody should be condemned, I would say. If he is not heard, he will say, I am condemned because you are not giving me a hearing. So this brings us to the premise of what is this maxim itself, that is Audi Alterem Partem. And the maxim simply means, I am going to simplify everything. The maxim simply means, friends, hear the other side. Audi Alterem Partem. The word Audi itself pertains to the ear. No man should be condemned unheard. No man should be not heard itself in the process. That is, everybody should be given a hearing. Now justice should be given to both the parties, and this maxim Audi Alterem Partem comes from a Latin phrase, that is audidatur et altera pars. This is what is the maxim. Come on, today there is a big debate whether this Latin maxim should be heard henceforth in Indian courts, right from the Supreme Court and the High Court, but then these Latin maxims have their own beauty. So let us go by that, and there is a very strong rule that nobody should be judged without a fair hearing. The judge, without hearing you, he passes a judgment. How would you feel? Well, let me tell you that if something is happening to somebody else, it's always funny. Well, the judge did not give him a hearing. So funny. And then he lost the case and he lost his property. If it's happening with the other person, it is always funny. The point is, all seriousness starts when it starts happening to you. And we are all equal, so all rights should be equally administered. So if at all he is to be given a right to be heard, I also should be given a right to be heard. And the motive of this maxim is to provide an opportunity to the other party to respond to the evidence which is given against him. Well, your opponent has given this sort of an evidence. Do you want to say something in your defense? This is what exactly we see. And then we see there are so many juries and so many things have been said on this maxim. Lord Evershed MR, Lord Escher MR, Lord Escher said that natural justice is it's in a natural sense. We have to rectify the wrong with what is right. So there is a rectification in the natural sense of a wrong by something which is right. Yes, friends. Friends, now we see that this right of hearing passes through various stages. The first stage is the notice itself. Well, there is some matter going against me, some case. How do I know? So there ought to be a notice against me, and before you take any action against a party, you should give him a notice. In courts you see there could be a summons. In departmental inquiries there is a notice. But a notice is a must. A notice must be provided to the other party to present a case against the cause which is, or the proposed action which is to be taken against him. The right to notice means the right to be known. Well, I know that there is some case pending against me, and then the notice comes. The further intricacies are that we have the notice by registered post or by email, because email is also an admissible piece of evidence today. The most important aspect of a notice is it should mention three things: date, time and place. If I tell you come for there's a departmental inquiry against you and come for the hearing, where to come? And you come in Shivaji Nagar, but Shivaji Nagar is such a big area. Where in Shivaji Nagar? Or you come on Mahatma Gandhi Road. There is not a single town in India which does not have a Mahatma Gandhi Road. And I say you come on Mahatma Gandhi Road. No, where? The address should be there. Date should be there. Time should be there. Come at 8 o'clock. But 8 o'clock when? In the morning or in the evening? So it's in the fitness of things, friends, that we mention it. The timings as per the railway timetable, I will meet you at 20 hours. And the date is also final. And the date has to be the English calendar. Sometimes people mention the Hindu calendar and sometimes the Urdu calendar and this and that. There could be so many. We will stick by the the British calendar. That is date, time, place and the place of the hearing. When all these things are over, the notice is perfect, and it should also contain the charges which are proposed against the concerned person. Now friends, in Keshav Mills versus Union of India, Supreme Court held that the notice given should be to the party should be clear and unambiguous. If it is vague, if it does not convey anything, you must have seen people give addresses. Come in this area and ask anybody my name and he will bring you to my house. This is no way of giving an address. Address should mention particulars as are provided in the post office. How do they know? There should be a pin code, there should be which street you say, house number, this, that, and explain it in reasonable terms so that somebody who brings you the notice understands what it is. Otherwise, the notice is not reasonable and proper. And then next part is that there ought to be a hearing. This is the second most important part in the maxim Audi Alterem Partem. There should be a fair hearing, and if the order passed by the authority is without any hearing, then it is an ex parte order. Of course, the law allows ex parte orders, but then there is a caveat to that. When would that be? That I gave him 100 notices, but this person did not turn up, or he is not turning up, then an ex parte could follow. Otherwise, giving a hearing is rule number 1. Ex parte would be an exception. If these conditions are fulfilling, then there could be an ex parte order. Now in the Harbanslal case versus or National Cooperative Bank case versus or Fateh Singh versus State of Rajasthan, I mean, it was held, the common thread is that there must be a reasonable opportunity of being heard or to defend a person. If I am the person, I have to defend myself. So there should be a reasonable opportunity of being heard, or the person has to have an opportunity to defend himself. And this is accompanied by providing written and oral evidence, because that constitutes a part of the hearing. When you are going to hear a person, are you just going to give him a hearing without allowing him to produce any evidence? Are you going to say, okay, I am hearing you, but don't produce the documents? No. Evidence includes all of these things, and evidence is the most important part of the hearing. So in simple words, friends, both the parties would be allowed to put forth their evidence. And in case of say Stafford versus Minister of Health, this is a very landmark case wherein it was held that no evidence should be received in the absence of the other party. When you give him, well, where is his signature? Say for example, in a departmental inquiry you produce the papers. Papers are acknowledged by the other party. Yes, he's got it. Then only you can say that there has been a proper service. Both the parties should be appraised of as to what is the evidence which is to be led, what are the documents, what is his side, what is my side, and then only you can say that the documentation is perfect, which is a part of a hearing and it constitutes a part of the fair hearing. Now, I was just mentioning you the case, that is Trehan versus Union of India, post-decisional and pre-decisional hearing. I mean, it doesn't appeal to the conscience of a person that after the decision is over, you say you are going to give me a hearing, and what's the use? But this is exactly what is held in Trehan's case, wherein the honorable judges said that a post-decisional hearing is better than a no hearing itself. So it operates this way. And finally, we are having some exclusions of the principles of natural justice, and the first one is the doctrine of necessity. That it is so necessary to set aside the normal procedure, legal procedure, so as to prevent a greater harm from occurring. Now friends, you say in Ashok Kumar Yadav versus State of Haryana, what had happened is a member of the public commission was not allowed in the selection process itself, which was struck down. And the Supreme Court held that it cannot be this way, that you exclude a member of the public commission from the selection process. Second is the statutory exception. Statute is the law. The law itself says that this will not be followed, and then it need not be followed. And here what we see is situations where the provisions of a statute or law may override the principles of natural justice. For example, say in national security or public safety, the government will be authorized by the law to take action without giving a hearing to each and every Tom, Dick and Harry. This is not possible. Security is more important. Public good is more important. Between two evils, we have to select a lesser one. Third is emergency situation. Think of a situation at the Kargil border. Pakistan is showering bombs on India, and what are we to do? Give each other a hearing? What is government supposed to do? So it's in your protection and my protection, and in the national interest that some natural justice principles will be suspended. If it jeopardizes the interest of the public at large, then the natural justice will have to give way, and the government will take its decision to the exclusion of the principles of natural justice. Lastly is public interest also. Public interest is an exception because it's in the interest of society. The largest good of the largest number of people is to be seen, and if the society itself is at stake, then the individual rights should give way to collective rights. And lastly, it's impracticable situations. Impractical situations is certain situations may be impracticable for a person or a group to receive equal treatment because of the circumstances of the available resources. Say for example, in Bihar School Examination Board versus Subhash Chandra Sinha, in this case, there was a mass copying. This case is of mass copying. How many students copied? So many of them. Are you going to give each and every student a hearing? It is almost impractical, is what the Honorable Supreme Court said. So this was an exclusion of the principle of natural justice. So friends, we have seen Audi Alterem Partem, and our journey to gather knowledge continues at Simzuu. Next time we come with a new video, with a new concept in labor law. Thank you, friends.